Honorable Dr. R.R. Singh, Minister of State for External Affairs of India, Honorable Justice Chandrachud, Chief Justice of India, Honorable Mr. R. Venkataramani, Attorney General for India, Mr. Fali Nariman, Senior Advocate, Supreme Court of India, and Chair of UNCCI, Ms. Anna Joubin-Bret, Secretary of UNCITRAL, Senior Justices and Advocates, Excellencies, Ambassadors and High Commissioners, and distinguished guests. A very warm welcome to the 2023 UNCITRAL South Asia Conference. To begin with the conference, I would like to invite the esteemed speakers to join us for lighting the traditional lamp. So this conference today is being co-hosted by Ministry of External Affairs, the United Nations Commission on International Trade Law, and the UNCITRAL National Coordination Committee India, UNCCI. Over the course of 3 days, we will delve into the themes ranging from digital economy, MSMEs, and the ways to enhance their access to credit, alternate dispute resolution in the context of addressing financial difficulties, and the role of courts in this regard, some regional perspectives on UNCITRAL, the investor-state dispute settlement reforms to commercial mediation and arbitration, and among all, how to make India a hub for international arbitration. The primary objective of this conference is to encourage interaction between UNCITRAL, the judiciary, the bureaucracy, academia, and legal practitioners to deliberate on the work agenda of UNCITRAL and its various texts for the harmonization of international trade law, their implications for India and the South Asian region at large. So just to give you a brief background, India is a member state of the UNCITRAL from its very inception in 1966. Having been a member throughout for more than 5 decades, India was chosen as a venue for the Golden Jubilee celebrations of UNCITRAL on completion of 50 years of its existence here in New Delhi in 2016. That conference was also inaugurated by the then Honorable Chief Justice of India along with the Honorable President of India, and saw participation from around the world. And as a follow-up to the 2016 conference, we all have gathered today here to commence the 2023 UNCITRAL South Asia Conference. Welcome to one and all. Now, without further ado, I would like to welcome our first speaker for the evening, Ms. Anna Joubin-Bret. Ms. Anna is the Secretary of United Nations Commission on International Trade Law and the Director of the International Trade Law Division in the Office of Legal Affairs of United Nations. Prior to her appointment, Ms. Anna practiced law in Paris, specializing in international investment law and arbitration as counsel and arbitrator. She holds a DEA in private international law and a master's degree in international economic law from Paris First. Thank you. Over to you, Ms. Anna. You have to use that second.
The Honorable Dr. Justice D.Y. Chandrachud, Chief Justice of India. Dr. Rajkumar Ranjan Singh, Minister of State for External Affairs of India. Mr. R. Venkataramani, Attorney General for India. Mr. Fali S. Nariman, Senior Advocate, Supreme Court of India and Chair of the UNCITRAL National Coordination Committee of India. Justices of the Supreme Court and High Courts of India, Excellencies, distinguished speakers and participants. It's my great honor to deliver co-opening remarks for the 2023 UNCITRAL South Asia Conference, jointly hosted with the Ministry of External Affairs of India and the UNCITRAL National Coordination Committee of India, UNCCI. Conceptualized during my 2019 visit to Delhi with our good friends at the Ministry of Foreign Affairs, I am delighted that after a 3-year hiatus, we are finally able to continue face-to-face the important dialogue on global standards for rule-based commerce convened in India in 2016 to celebrate the 50 years of UNCITRAL. This iteration is especially meaningful as it is the first flagship event organized by the UNCITRAL Regional Center for Asia and the Pacific in South Asia since the pandemic. My special thanks go to our partners, the organizing team at the Ministry of External Affairs of India, and to UNCCI for the excellent arrangements bringing together my distinguished co-speakers and over 200 senior members of the judiciary, government, academia, and legal practitioners from India and the international community. UNCITRAL highly appreciates its long-standing ties and close cooperation with the Indian government and is grateful for India's active involvement and contributions to the work of UNCITRAL and its working groups. UNCITRAL is also grateful to UNCCI, India's national clout correspondents, and the expert speakers who have traveled from all corners of India and the region and beyond for some to share valuable insights. We continue to count on your support at this crucial juncture for international trade. For our part, the Secretariat is present in full force, perhaps the largest grouping outside of Vienna headquarters or Incheon in the Republic of Korea, where UNCITRAL RCAP is located, and we are very eager to engage with and to learn from all of you. Over the next 3 days, you will be hearing from my colleagues, Senior Legal Officer Samira Musayeva on ADR and insolvency matters, Senior Legal Officer Jae-Sung Lee on access to credit for micro, small, and medium enterprises, and investor-state dispute settlement reform, Legal Officer Luca Castellani on the digital economy, Head of the RCAP Atita Commander on commercial arbitration, and RCAP legal expert Tracy Choi on commercial mediation. And I look forward to joining the high-level roundtable. Before we delve into these discussions, allow me to provide updates on the newest UNCITRAL convention and on the Commission session in July on dispute settlement, ISDS reforms, MSMEs, and development on other topics. The United Nations Convention on the International Effects of judicial sales of ships, better known now as the Beijing Convention on the Judicial Sale of Ships, opened for signing last week on 5 September in Beijing. 15 states signed the convention at the ceremony, which was attended by senior officials and representatives from more than 30 states. It will remain open for signature thereafter at the United Nations headquarters in New York and will enter into force 180 days after the date of the deposit of the third instrument of ratification, acceptance, approval, and accession. And we look, of course, very much forward to India's participation in this meaningful instrument. Adopted by the General Assembly on 7 December 2022, the Convention establishes a harmonized regime for giving international effects to judicial sales while preserving domestic law governing the procedure for the judicial sales and the circumstances in which judicial sales confer clean title. By ensuring legal certainty as to the title that the purchaser acquires in the ship as it navigates internationally, the Convention is designed to maximize the price that the ship is able to attract in the market and the proceeds available for distribution among creditors, and of course all of this while promoting international maritime trade. The General Assembly has called on all states wishing to strengthen the international legal framework for shipping and navigation to consider becoming a party to this convention. Turning now to the Commission, as a result of the work undertaken by Working Group 2 on dispute settlement, UNCITRAL adopted a guidance text on early dismissal and preliminary determination at its latest session in July. This text will be included in a revised version of the UNCITRAL notes on organizing arbitral proceedings. It illustrates the discretionary power of an arbitral tribunal operating under the UNCITRAL rules or other arbitration rules to dismiss a claim or defense or make a preliminary determination to that effect based on the manifestly without merit standard. It is hoped that this addition will make it easier for arbitral tribunals and arbitration practitioners to utilize this tool, and it will help discourage frivolous claims. On investor-to-state dispute settlement reform, you may recall that Working Group 3 was entrusted in 2017 with a broad mandate to work on the possible reform of ISDS. Following several years of extensive preparation and deliberation, UNCITRAL adopted a first batch of texts, namely the UNCITRAL model provisions on mediation to be included in existing and future investment treaties, the UNCITRAL guidelines on mediation for investment disputes, the UNCITRAL Code of Conduct for arbitrators, and the UNCITRAL Code of Conduct for judges at the same Commission session in July. This year marks an important milestone as Working Group 3 is in its third phase of work to develop relevant reform solutions and present them to the Commission. And you will be hearing more about the work of Working Group 3 in the course of this event. As another significant work underway, I would like to take this opportunity to highlight UNCITRAL's dispute resolution in the digital economy, as an acronym DRDE project. Through the project, the Secretariat is in the process of exploring the impact of digital technologies and technology-enabled services on dispute resolution. The technologies and technology-enabled services being explored range from online platforms to artificial intelligence and blockchain. As UNCITRAL is a legislative body, we are doing this with a view to updating existing UNCITRAL texts or developing new ones. Having considered the Secretariat notes on preliminary findings of the mapping exercise to identify the legal issues at its recent session, the Commission expressed its strong support for the Secretariat to continue its activities and put forward concrete work proposals for the Commission's consideration in the ways to develop norms fit for the digital age. We're committed to further implementing this important project and count on the support of contributors from all regions and, of course, including India. But UNCITRAL's mandate goes beyond dispute resolution and covers a number of other topics in international commercial law. Since 2013, UNCITRAL has been working on an enabling legal framework for MSMEs by addressing the legal obstacles they face throughout their life cycle, particularly in developing economies. And please allow me to thank India for its strong support, including at the United Nations General Assembly, when UNCITRAL's report is being presented for the work on MSMEs. After working on business registration and a simplified form of limited liability enterprises for MSMEs in July, the Commission adopted the UNCITRAL Guide on access to credit for micro, small, and medium-sized enterprises, completing the work it had initiated. The text recommends state reforms in certain areas of private or commercial law that may help to ease issues MSMEs, in particular micro and small enterprises, face in accessing credit. It refers to policy and regulatory measures that can enhance the effectiveness of the legal framework, and in recognition that poverty of women is directly related to unequal access to economic opportunities, and that women-owned MSMEs often face higher barriers than those owned by men, and it encourages states to adopt the necessary measures to ensure equal access to credit for women entrepreneurs. Another recent text for small businesses is the UNCITRAL Legislative Guide on Insolvency Law for Micro and Small Enterprises, adopted in 2021 during the pandemic, which has seen so many of the small and medium enterprises falling victim of the economic consequences. The legislative guide was adopted to take into account the unique characteristics of MSMEs, such as intermingled business and personal debts, centralized governance model, in which ownership, control, and management often overlap, to respond to the specific needs and circumstances of their financial distress. In addition, I would urge India to consider the enactment of the UNCITRAL Model Law on Cross-Border Insolvency, which in a recent case appeared to have been read into the Insolvency Code framework by the National Company Law Appellate Tribunal, and which we understand is part of India's package of measures for insolvency law reform. Two other recent UNCITRAL texts complementing that framework are the Model Law on Recognition and Enforcement of Insolvency-Related Judgments of 2018 that assists states with modernizing their domestic legal framework with regard to the recognition and enforcement of insolvency-related judgments, and the Model Law on Enterprise Group Insolvency of 2019 that states can enact to build a modern legislation for addressing the domestic and cross-border insolvencies of enterprise groups, supplementing the model law that focuses on cross-border insolvency proceedings concerning a single debtor. I would also urge India to actively participate in the current work of Working Group 5 on applicable law in insolvency proceedings and civil asset tracing and recovery of assets for the insolvency estate. Texts on those subjects are expected to enhance the UNCITRAL cross-border insolvency framework. Turning now to the digital economy, I arrive in New Delhi on the heels of the third Incheon Law and Business Forum, a flagship conference organized by UNCITRAL every 2 years. Themed from documents to data, legal and commercial solutions for digital trade, the conference focused on both the legal and business implications of paperless trade facilitation, including pilot projects and business solutions for its implementation, and the adoption of the UNCITRAL Model Law on electronic transferable records. It pleases us very much to understand that the high-level principle on digitalization of trade documents have been recently adopted by the G20 trade and investment ministers during the Indian presidency. Those principles clearly support the consideration of UNCITRAL texts. And in doing so, they contribute to the trend that actively promotes the adoption of UNCITRAL texts to establish legal predictability on crucial aspects of the digital economy, both domestically and across borders. In that regard, please allow me to recall that UNCITRAL texts on electronic commerce, as they are traditionally referred to, although we prefer to call them now on digital trade, have already been adopted in more than 100 states, including virtually all of South Asian states. Building on this significant legacy, UNCITRAL has recently prepared legislative texts that are considered by stakeholders particularly timely and relevant. The effects of the COVID-19 pandemic on trade have highlighted the need to build resilient and robust supply chain accompanied by the full digitization of all commercial documents and the assurance of data quality of the messages exchanged, for instance, with regards to their integrity and origin. The UNCITRAL Model Law on Electronic Transferable Records and the UNCITRAL Model Law adopted last year on the use and cross-border recognition of digital identity management and trust services provide the legal building blocks to achieve that goal. UNCITRAL Working Group 4 is continuing in exploration of the frontiers of innovation and the law by working on contract automation, including with AI, and transactions on data. These two closely related topics get to the heart of digital transformation. I would like to close with a word on future work. As the legislative body of the General Assembly of the United Nations, UNCITRAL cannot ignore the general mobilization of states and the entire United Nations system to fight against global warming and its disastrous consequences for our planet and for our children. To reflect and work on the best way of how UNCITRAL can make its contribution, however modest, to this commitment of the international community, the Commission requested the Secretariat to organize at its recent session a colloquium on climate change and the law of international trade. The colloquium considered areas in which international trade law can effectively support the achievement of climate action goals set by the international community, the scope and value of legal harmonization in these areas, and the needs for international guidance for legislators, policymakers, courts, and dispute resolution bodies. In particular, the colloquium considered the contribution that UNCITRAL, as an inclusive forum to devise global solutions, could make in the light of its mandate to promote the harmonization and modernization of international trade in the form of work on existing but also new UNCITRAL instruments in contract law and electronic commerce, and insolvency, secure transactions, public procurement, public-private partnerships, and dispute resolution. As the G20 Trade and Investment Ministerial meeting recently concluded in Jaipur attests, India's leadership in international commercial matters is critical, and its importance as a current and future contributor to the development of legal standards both within the Asia-Pacific and globally cannot be overstated. I very much look forward to our invigorating discussions over the course of this conference on how we could work together to strengthen a legally enabling environment for international trade in India and beyond, with gratitude again to our co-hosts, the Ministry of External Affairs of India and the UNCCI. Thank you once more for this honor and best wishes for a successful conference.
Thank you, Secretary Anna. Our next speaker for the evening is Honorable Mr. R. Venkataramani, Attorney General for India. Lawyer, jurist, activist, and a mentor to many, Mr. Venkataramani is currently serving as the 16th Attorney General for India. He has been a senior advocate at the Supreme Court of India and is a well-respected constitutional lawyer of the country. He is the first advocate on record to be appointed Attorney General for India. He has been a part of the South Asian Task Force on Judiciary, consisting of members of SAARC nations. He has also worked with the International Court of Justice on its activities in the Afro-Asian region and drafted an instrument on the right to food in Berlin. Sir, over to you.
Honorable Chief Justice of India, and Ms. Anna, my first introduction to you on a very warm note, and Dr. Rajkumar, Ranjan Singh, Honorable Minister for State for External Affairs, and my esteemed guide and mentor, Mr. Fali as Nariman, and without whose physical presence today, the event would have been incomplete. On 28 November 2016, the Honorable President of India spoke at the Golden Jubilee celebrations of UNCITRAL and hailed it as one of the most contributing UN organs. The Honorable President truly perceived UNCITRAL as an invaluable platform enabling countries to compare, examine, debate, and adopt principles both of universal and domestic importance and relevance. The harmonious and non-political nature of deliberations at UNCITRAL was rightly appreciated. Those were prophetic words looking towards progressive set of norms and rules that can be safe resting grounds for all nations on the common engagement of promoting international common goods. I'm indeed more than delighted today to be called upon to warmly invite all the UNCITRAL community who have open minds, keen intellects, common aims, and sharing inclinations, all driven by the common urge to constantly refine and improve our principles and exchanges. This common urge is ancient as the Silk Route of the past. From the limited persuasions towards building laws only partly common to all humankind, we are in the midst of capturing persuasions towards building laws both of universal content, but with necessary diversities that can add to the richness of the universal content. The narrow channels of knowing each other through limited editions of knowledge and conditioned by a host of historical factors have given way to being with each other at the global level. We understand the need for constitutional rather than managerial mindset for transforming international law. What is said, as I quote, an international order based on more and more inclusiveness and embedded liberalism is what should be the driving force behind our common urge towards common public goods. The inclusiveness of dialogue is not only more and more for ideas from all over, but also room for being in as many places as we should be. I fondly bring to the fore the essays published in honor of legendary Fali Nariman, a rich collection of ideas and propositions, sprinkled with a gathering of equally rich and long-lasting contributions of Mr. Nariman to the arbitration world. The arbitration world does not exist without his name. It is my honor to be with him today, and like a Lilliputian gather a few humble insights from the vast playfield built by him. Rightly had the title of the book, International Arbitration Rule of Law, been chosen. The rule of law we intend to talk and reflect is itself a vast canopy of ideas and togetherness, mediated by the common need for mediated and shared world of thoughts and precepts. An end-of-history perspective floated by Fukuyama will be attractive for political visions or ideologies, may not do justice to the world of justice and the ideas of justice. The last refinement of doing justice will always remain a challenge. So it is that we have assembled here today to put all our thoughts and urges to celebrate UNCITRAL. And in UNCITRAL is here, I consider the United Nations is here. And to draw a canvas that can keep us together on the pursuit of common goals. Speaking on behalf of India, I consider the sooner than expected UNCITRAL congregation here as India's humble contribution towards the discovery of the Commonwealth of Justice and Peace in the world of trade, commerce, and the new domains of human and natural resources shaped by technology. In his 2013 monograph titled The Geneva Consensus, Making Trade Work for All, the former EU Trade Commissioner Pascal Lamy promoted the Geneva Consensus as an alternative to the neoliberal Washington Consensus, and he emphasized on, I quote, stronger policy coherence through better coordination among the legally separate international, monetary, financial, trade, investment, environmental, and human rights institutions and policies in order to enhance their potential synergies. I quote. On the other hand, we listen to the criticism about privileging foreign investor rights without adequate regard to regulatory duties of host states, reconciling investment regulation with economic and non-economic public interests or public goods, subject to which, too, is a matter of genuine concern. All these need to be debated while we talk about the urgency to bring about expedition and coherence in the arbitration world and redrawing conflict of principles and rules to raise the importance of fairness in all aspects of economic transactions and outcomes. I think all these may mean multi-level judicial and rule committee. A little digression may be granted. Anarchism is a learner's field. Domestically, we keep critiquing the entrenched anarchism in the arbitration world, though one can notice creation of ad hoc tribunals anywhere in the world, as in the awards in CME versus Czech Republic or LADA versus Czech Republic. So also cases pertaining to foreign investments fall frequently within the wide range of activities of the PCA. Even though we have traveled fairly long distances in our bilateral treaty processes and learned from experiences, touching upon even definitional issues such as investment or dispute, we are occasionally drawn into the legal or political nature of a given dispute or the element of directness of the dispute to investment. Few other issues also seem to arise, such as the unity of investment, indirect investment, the legality of investments, the origin of the invested funds, etc. The exit convention experiences and rules on constituent subdivisions and our own lessons on such matters also demand quick attention. The scope and irrevocability, consent to arbitration or interpretation of consent continue to be matters of arguments and contests. The fork in the road provision provides interesting examples of understanding the triple identity test and their application. Some emerging examples of establishment of a permanent international investment court system to adjudicate investment disputes may also be noticed. What I have in mind is the EU example of setting up a multilateral investment court. Brazil is another example of which so far stayed outside the investment world. This time, Brazil has come up with an investment cooperation and facilitation agreement, ICFA, different from the traditional BITs. Rather than aiming to protect investment, they seek to facilitate and encourage it by setting rules for cooperation and risk mitigation. Thus, we see about that the above trends into the world of investment disputes resolution mechanism as also slowly moving away from the existing institutional mechanisms. A 2021 study on the work of UNCITRAL Working Group 3 by Friedrich Ebs Stiftung, a German think tank, offers an interesting framework for discussions on the multitude of proposals touching upon a unified dispute resolution authority in the field of investment law, and also paying attention to matters such as importance of diversity and sustainable development. We always remind ourselves that promotion of optimistic but unrealistic alternatives can dissipate the momentum for real reform. As I understand, all investments, intellectual and material, must now be in the service of sustainable development. We also notice that in most cases, an investment arbitration applicable substantive law combines international law and the host law. Tribunals, in the majority of cases, have applied both systems of law. Studies looking at investor treaties and arbitration have also critiqued significant inconsistency in tribunal awards. Some of the studies, for example, International Economic Law, the State and the Future of the Discipline, and or proportionality and deference in investigative arbitration are powerful persuasions demanding probing exchanges. I do not propose to exhaustively catalogue the chapter titles for discussion in the conference, as that would be the prerogative of more informed minds. Finally, the Office of Attorney General gives me the authority to make a nation-friendly and a host country statement. India has made all the final arrangements for PCA to have its seat in the ancient land of ahimsa and bondage of diversity. This long-pending agenda has moved finally into its ribbon-cutting stage. Maybe a long gestation brings a healthy baby. I congratulate the deep and abiding commitment of Government of India to their global commons where creativity, innovation, and liberty, consistent with equality and fairness, will usher in new understandings of resources sharing, and to the significant nod of welcoming PCA as an important domestic partner, which will carry all the players in the arbitration world into exploring the ideas of sharing in fertile and novel ways. We will very soon fix the best and auspicious day and invite all of you for another sumptuous day of many treats. India has crossed another milestone. The India International Arbitration Center Act 2019 has come as a much-needed statutory intervention. This law will facilitate growth of robust institutional structures, in turn providing for significant institutional connections, both domestic and global. An expeditious transition into institutionalizing the Indian arbitral world is expected to happen, with the IAAC being headed by a former judge of the Supreme Court, and having been declared as a center of national importance, one can visualize greater expedition and all-round motions in the Indian arbitral world. The world of treaties, the debates on the redrawing the contours of the bilateral and multilateral treaties, the discussions in the Working Group 3 of UNCITRAL on ICS reforms, etc., as also a multilateral investment dispute resolution institution are all matters which may give us many more insights about the road ahead. The idea about international investment legal framework seems to have already directly and indirectly entered our discourse. I may not be wrong in stating that UNCITRAL will be the resource venue and platform of taking stock of all of this. International investment law is anything but international. It's stitched together by a cobweb of bilateral investment treaties reflecting local concerns and priorities. The elements of IAAs are unidimensional, and the template is so far prepared by a narrow set of capital exporting countries. These instruments have led to spread of inequitable norms, practices, and outcomes, which need to be deleted. These norms and practices have also become somewhat immutable, leading to stagnation. There is a pressing need to revisit the template and content of the current model of investment treaties. I wish to make a case for why a New Delhi Declaration on Global Investment Law, spearheaded by India, is a need of the hour. The current dialogue which India is engaged in with few countries and revised bilateral norms should also help us in this regard. Much more than what I have talked about will be debated in the coming 2 days. If the appeal being made here for greater global or international sharing has to be realistic, my talk today will be incomplete if I do not look forward to the New Delhi Convention, not because we only want to compete, but because ideas and exchanges must find more and more hospitable places for their sprouting and growth. Thank you for your attention.
Thank you, sir, for your remarks. Our next speaker is Dr. Rajkumar Ranjan Singh, Minister of State for External Affairs of India. Dr. Singh officially took charge as Minister of State for External Affairs and Education on 8th of July 2021. He's a postgraduate in geography and has earned his PhD from Guwahati University. He has published 8 books and made numerous contributions to various national and international journals and publications. During his academic career, Dr. Singh has also participated in several national and international consultative meetings on human resource management, security sector reforms, and land and livelihood rights of indigenous people. Sir, I invite you to provide your remarks.
Thank you. Honorable Chief Justice Dr. Chandrachud ji, Excellencies, High Commissioners and Ambassadors, Honorable Judges of the Supreme Court and High Courts, learned Attorney General for India, Shri Venkataramani ji, Secretary of UNCITRAL, Madam Anna Joubin-Bret ji, Senior Advocate and Chair of UNCCI, Shri Fali, Nariman ji, distinguished speakers and delegates, ladies and gentlemen, Namaste. A very warm welcome to India and this opening proceedings of the 2023 UNCITRAL South Asia Conference. It is a distinct privilege to stand before you today in this gathering of brightest minds dedicated to studying, harmonizing, and advancing international trade law, particularly laws and rules on investment and dispute resolutions. This conference is a significant milestone in fostering collaborations and dialogue among the stakeholders. The Ministry of External Affairs is happy to facilitate it. I am honored to be a part of this STEAM gathering. Friend, let me begin by congratulating UNCITRAL for the finalization and adoption of text on UNCITRAL model provision on mediations, the UNCITRAL guideline on mediation for international investment dispute, and the UNCITRAL Code of Conduct for arbitrators in the recent held 56th session in Vienna. The United Nations Commission on International Trade Law has played an instrumental role in furthering, harmonizing, and unification of the private law of international trade in the interests of all people, in particular those of the developing countries. The legal texts and model law developed by the Commission are directly relevant to commercial transactions of the individual, corporations, and state, and thus have practical value for all. India shares a unique relationship with UNCITRAL. From being elected as one of the 29 states as member of the Commission in 1967, we have actively participated and contributed to the development of the New York Convention. We enacted our Arbitrations and Conciliation Act in line with the UNCITRAL model law on international commercial arbitration to signify our commitment to modernizing an arbitration framework according to the international best practices. India celebrated UNCITRAL's turning 50 by hosting a conference, the only such event in the entire Asia-Pacific region. India has also been at the forefront of UNCITRAL's initiatives and play an active role during the last conference in India and thereafter when UNCITRAL deliberated on its future work by actively engaging in discussion on ISDS reforms. India also coordinated the informal meetings of the legal advisors of the ministers of foreign affairs of the UN member states. Today, as we gather here, we are again coordinating the informal meeting of the legal advisors. Ladies and gentlemen, over the years, we have continued to align our laws and regulation with various UNCITRAL texts on international trade, commercial conduct, and dispute resolutions. These alignment, I believe, have indeed contributed in ease of doing business and promoted international trade and investment in India. We are investing in modernizing our infrastructure as we work towards a $5 trillion economy. Today, we are making for the world. Our exports are growing at close to 14%. Export figures of more than $770 billion is a key milestone in our Atmanirbhar Bharat journey. Our latest foreign trade policy delineated pathways for a $2 trillion export economy by 2030. In this backdrop, this conference assumes critical importance. At the heart of the UNCITRAL work lies the principles of inclusivity, the motto that international trade law should be accessible to all nations regardless of their size or economic power. This inclusiveness is particularly relevant in the context of the South Asia, where countries vary greatly in terms of their legal traditions and economic development. As we gather here, we recognize India is but one of the many countries with immense diversity and rich cultural vibrancy in the South Asian region. We remain of the rich tapestry of nations and make up our collective identity. South Asia is a mosaic of cultures, languages, traditions, and aspirations. They all contribute uniquely to the dynamic fabrics of our shared history. Our region is young and dynamic. Our economies are poised for further expansion. However, to realize our full potential, we must ensure that the legal infrastructure supporting trade and investment is robust, efficient, and conducive to growth. We seek to collaborate with South Asian neighbors to promote arbitrations as a preferable method for dispute resolution within the region. By fostering an arbitration-friendly ecosystem, we aim to enhance economic cooperations and trade within South Asia. A wide range of topics, from the digitizations of the trade procedures to the harmonizations of commercial laws, will be discussed in this conference. I am sure this discussion will not only deepen our understanding of the international trade law, but also provide practical insight into how we can improve our legal framework to facilitate trade and investment. I am confident that this conference will serve as a catalyst for enhancing cooperation and collaboration among the South Asian nations. I thank the Honorable Chief Justice of India for taking time out of his busy schedule on a working day and joining us here along with other members of the higher judiciary and legal fraternity. I would like to extend my heartfelt gratitude to all those who have worked tirelessly to organize this event. The collaboration between our ministry, UNCITRAL, and UNCCI underscore the importance of multilateralism and the shared vision of creating a world where trade, investment, and dispute resolution thrive within a framework of fairness and equity. I wish you all the success for a dynamic productive, and intellectually stimulating conference ahead. Thank you once again. Jai Hind.
Thank you. Our next speaker is Honorable Dr. Justice D.Y. Chandrachud, Chief Justice of India. Justice Chandrachud is the 50th and the current Chief Justice of India since November 2022. He holds a Bachelor of Arts in Economics Honours from St. Stephen's College, Delhi, an LLB degree from Delhi University, an LLM and SJD from Harvard Law School. He is a visiting professor of comparative constitutional law at the University of Mumbai and Oklahoma University School of Law, USA. He has been a speaker at the conferences organized by various UN bodies, including UN High Commission on Human Rights, International Labour Organizations, United Nations Environmental Programme, the World Bank, UNCITRAL, Permanent Court of Arbitration, and Asian Development Bank. He has delivered many landmark judgments, including in the field of arbitration, such as the Centro Trade case on appellate mechanism in arbitration, the AFCONS case on arbitrator fee, and the Gurgaon Rapid Metro case, which have contributed to the development of jurisprudence in international arbitration. Sir, please enlighten us with your remarks.
A very good evening to all of you. Ms. Anna Joubin-Bret, Secretary of UNCITRAL, Mr. R. Venkataramani, the London Attorney General for India, Dr. Rajkumar Ranjan Singh, Minister of State for External Affairs, Mr. Fali Nariman, eminent senior advocate, thinker, mentor, visionary, and chairperson of the UNCCI, distinguished colleagues in the Supreme Court, of the High Courts, Your Excellencies, and ladies and gentlemen. At the outset, I would like to congratulate UNCITRAL, the Ministry of External Affairs of the Government of India, and the UNCITRAL National Coordination Committee of India for their joint effort in organizing this event, which reinforces India's decades-long engagement with UNCITRAL and facilitates the exchange of ideas and perspectives among South Asian countries. I'm truly delighted to be able to deliver the inaugural address at the South Asia Conference, which was last held in India in 2016. I had the undiluted pleasure of being in the audience in that conference, in the inaugural session. Then too, I had the pleasure of attending the conference. I believe that the conversations which take place at such events serve as a sounding board for ideas that morph into best practices. Some of those best practices are incorporated into law. We have each amassed years of institutional experience, and through deliberative efforts such as this conference, are able to share insights from our own experiences with one another. Even as our own experiences guide us, we must each learn from other countries and the successes and difficulties that each country has faced with its people, business, and legal systems. There's no point in brushing our failures under the carpet. This is all the more possible in this conference because South Asian countries have much and more in common. The many similarities in our cultural and social setup undoubtedly seep into our business practices and legal systems. Our economies are also interconnected, increasingly so in the digital age. Platforms such as Instagram have emerged as unlikely online marketplaces which facilitate business among the countries in South Asia. Our legal frameworks must have evolved in tandem with the expansion of the digital economy. I'm happy to share with you that last week, India and Singapore, through their Supreme Courts, signed a Memorandum of Understanding on advancing cooperation in judicial education and research. This is one of the many MOUs that India has signed with South Asian nations that foster knowledge sharing and collective advancement. Our judiciaries are walking in tandem. UPI has entered into a connection with Singapore's national platform for payments. When countries walk hand in hand, the progress of one becomes the progress of all. A tainted relationship, legal or otherwise, begets distrust. The parties battling this distrust must now brace for a legal battle and attempt to resolve their disputes. This is already a daunting and expensive process for most entities. Legal battles once begun have no end in sight. Ask me as a judge. And throw cross-border laws and international parties into the mix, and you have a dispute that makes for an even more expensive, time-consuming, and oftentimes confusing affair. As members of the legal community, we know better than anyone that this is hardly a profitable phenomenon, perhaps except for us, especially for smaller and mid-sized enterprises. Alternative dispute resolution mechanisms were previously considered to be rough justice, an imperfect substitute for judicial review by courts. Parties and jurors alike perceived arbitration and other out-of-court mechanisms as a deprivation of the opportunity to have their day in court. I believe that at least a part of this hostility stemmed from a lack of transparency about the procedures to be adopted and a lack of clarity as to the outcome of a challenge to a final arbitral award. Of course, new ideas and processes are initially viewed with mistrust. We have now moved far beyond this atmosphere of mistrust into calling ADR as appropriate dispute resolution mechanisms, our first line of fora for efficient, transparent, and certain dispute resolution. Sunshine, as they say, is the best disinfectant. Fortunately, UNCITRAL assisted countries in the simplification and uniformization of their laws and rules, which in turn has made the justice delivery system more accessible. The UNCITRAL model law framework seeks to harmonize laws in different jurisdictions in an attempt to overcome the friction that may result from our diverse cultural and legal landscapes. The success of its model law framework requires no explication. India's law on arbitration and conciliation has relied on the UNCITRAL model law. Legislative efforts in India in ensuring clarity, as well as judicial thrust on party autonomy, significantly reduce the sense of unease amongst contracting parties. With its eye on best practices, India has steadily charted a course where arbitrations are the preferred mode of dispute resolution. The Indian Council of Arbitration, our first ever national arbitration institution, was established in 1965. We now have about 35 such institutions across the country. There is a veritable competition for good governance among states in business dispute resolution. Typically, we think of federalism as a political concept, but truly, the Indian federal structure is now becoming a platform for healthy competition among states to produce the best business outcomes, including in dispute resolution. The Delhi International Arbitration Center, for instance, went from handling 78 cases in 2009 to 5,868 cases in 2022. In 2013, a survey of corporate outlook towards arbitration described India's future as an arbitrating country as cautiously optimistic. Today, I take the liberty to state that India's future as an arbitrating country is cemented. Mediation and arbitration result in a significant reduction of costs for the parties to the dispute. These savings are particularly beneficial for smaller or mid-tier enterprises who will not be required to shell out large sums by way of legal fees for court proceedings that may take years to conclude. As legal fees explode through the roof in India, the bottom line is engaging the attention of corporate India as well. Indian courts have encouraged the use of ADR mechanisms over the years. In enforcing arbitration agreements, they have remained watchful of attempts to undercut party autonomy by artfully drafted contracts. In ICOM Tele Limited versus Punjab State Water Supply and Sewerage Board, a decision of 2019, the Supreme Court struck down a term which required a party to deposit 10% of the dispute value as a precondition to invoking arbitration. In NTPC Limited versus SPML Infra Limited in 2023, one of the parties to the agreement in question sought to initiate arbitration, even though there was a settlement between them. A Supreme Court bench of which I was a part reiterated that disingenuous litigation cannot be tolerated in the name of party autonomy. I would also like to take this opportunity to share some recent initiatives of the Supreme Court of India with you. How can I miss this opportunity as the head of the family? In India and in other countries as well, private players are perceived as being technology friendly, while public institutions are thought to live in the Stone Age when it comes to the adoption of latest technologies. This is perhaps not an unfair perception, because government offices and courts are often late to the party. But lawyers and litigants have had cause to celebrate of late. From e-filing and record keeping to real-time information systems, everything is being done digitally. Electronic case management systems are available at the click of a button. Today, the Supreme Court of India has onboarded all its data on the National Judicial Data Grid in a new era of transparency and accountability. The Supreme Court issues entry passes through a virtual platform, almost 700 of them which are issued every day to people who visit our court. We live stream hearings of certain constitutionally significant cases, and we release transcripts of oral arguments in those cases. A friend once told me, a few days back in fact, that watching one of these live hearings on YouTube was better than watching a Netflix movie on occasion. These initiatives are with a view to making the courts accessible to the common person. I dare say that some of our technology-based initiatives have surpassed those of arbitrations. I was intrigued by the clout or the case law on UNCITRAL texts, an open access resource that contains decisions of courts and arbitral awards relating to UNCITRAL texts. A summary of these cases is made available on the searchable cloud database. I'm sure some of you would have benefited from the immense industry that has produced this resource. Similar to the cloud resource, the e-Supreme Court resource, the e-Supreme Court reports, or the electronic version of the Supreme Court Reporter provides free access in a searchable format to about 34,000 judgments of the Supreme Court of India since 1950 to lawyers as well as members of the public. All judgments are uploaded on the platform within 24 hours of pronouncement. In the interest of uniformity and harmonizing the manner in which the judiciary in India functions, we recently introduced a uniform citation system or a neutral citation system, which is now being followed across India. Like cloud, these initiatives aim to democratize access to information. The democratization of access to knowledge has helped break down monopolies based on old feudal structures. We are on the anvil of having a digital SCR in the very near future. The Supreme Court of India is launching into AI-assisted learning very shortly. Our judgments are being translated into every language which the Constitution recognizes. 9,000 of our judgments have already been translated into Hindi, and we are aiming to translate judgments using machine learning tools in all our languages to reach out to people, to make sure that the work of the Supreme Court is not just confined to lawyers and judges and academics, but reaches out to the homes of every Indian. The Supreme Court is about to enter into a memorandum of understanding with the Indian Institute of Technology at Madras with a view to leveraging AI into the work of the Supreme Court. As we tackle barriers to information and resources, we should begin to look beyond our traditional destinations for arbitration. Disputes are location agnostic, and so should their resolution be. Many businesses from Tier 2 and Tier 3 Indian cities have a commercial presence across the globe. This is undoubtedly true for businesses located in smaller cities in the countries of South Asia. Such parties who are not located in metropolitan cities must have equal access to resources which enable ADR. This conference is the ideal place for such a decision to begin. But it must not end here. We must find a way to make smaller businesses a part of our conversation in law. I'm told that UNCITRAL Working Group 3 is discussing investor-state dispute settlement reforms. I recollect addressing this topic in 2016 during my panel discussion at the UNCITRAL conference here in Delhi. At that point, the question of whether UNCITRAL should address ISDS reforms was unsettled. We have come a long way, COVID notwithstanding. At that point, the question was completely unsettled. Since then, the UNCITRAL Commission has just adopted the first text on ISDS reforms pertaining to the Code of Conduct for arbitrators and judges in the ISDS process, as well as mediations which take place during this process. This is an example of the pivotal role played by India at UNCITRAL, and particularly in having this topic allotted to a working group. The global community is yet to reach a consensus on some issues regarding investor-state disputes. For instance, some bilateral investment treaties envisage a permanent court as a forum for the resolution of disputes instead of arbitral tribunals, which have traditionally been the forum of choice. Such developments must be discussed by UNCITRAL's working groups. International investment law has been criticized for being disadvantageous to developing countries, particularly those in the global south. It is therefore essential that the formulation of any new systems in international investment law, such as the creation of a permanent court, adequately account for these concerns and ensure that they do not remain areas of concern. I'm glad that the Secretary General of ICSID, Ms. Meg Kinya, is here and will be speaking at the conference. While India is not a member of ICSID, it appreciates the contribution of ICSID to the various deliberations under the auspices of UNCITRAL. The need of the hour is a fair and balanced system for the resolution of investor-state disputes. If such an investment court were to become a reality, we must explore the possibility of floating courts instead of the traditional system where all parties travel to a single place where the court is located. This would make the court more accessible to all countries across the globe. The host country agreements with the PCA are one of the avenues by which this could be achieved. Perhaps it is also time for India to revisit its host country agreement with the PCA after more than a decade to explore the possibility of strengthening PCA's presence in India. This could see India as a seat or venue for investment treaty cases and promote international arbitration in India. Finally, I'm pleased to note that various international arbitral tribunals and institutions have curated regionally diverse panels of arbitrators. I'm certain that this diversity is a contributor to the success of these institutions in transcending geographical and cultural barriers. However, the gendered compositions in these panels are hard to miss. We face what is called a diversity paradox. That is, a mismatch between our stated objectives and actual appointments. Less than 10% of all Indian arbitrators on various international institutional panels are women. ICC's 2022 report on gender diversity identified an unconscious bias as contributing to this problem. It suggests using gender-neutral pronouns in our legislation and rules. We have made an effort in that direction by launching the Gender Handbook in the Supreme Court of India just a couple of weeks ago, which tends to replace the gender-skewed language of legal discourse in our legal and judicial institutions. I hope that our Gender Handbook will take the theme of discussions beyond public law into more profitable commercial spaces. It is heartening to note that some arbitration rules have taken the cue in employing gender-neutral pronouns in their texts. However, the overwhelming majority of empaneled arbitrators are men. Women, as persons of all genders, belong also in all institutions of dispute resolution. Speaking of, and more importantly, speaking to some of these issues is critical to the development of law and policy on dispute resolution. I congratulate the organizers for the choice of issues slated to be discussed here. I look forward to the lively discussions that will ensue in the course of this conference. Hopefully, it will be a harbinger for change and a rethink on critical issues which confront us today. Thank you very much.
Thank you, Justice Chandrachud. Our next speaker is Mr. Fali S. Nariman, Senior Advocate, Supreme Court of India. Mr. Fali Nariman is an eminent jurist and needs no introduction. He began his practice at the Bombay High Court and was appointed a senior advocate in the Supreme Court of India in 1961. That is before even UNCITRAL began its journey. He was president of the Bar Association of India from 1991 to 2010. He has also been a member of parliament. He is an internationally acclaimed jurist on international arbitration. He's one of India's most distinguished lawyers and has argued in several landmark cases. He was the first Additional Solicitor General of India. He is the chair of UNCCI since its inception and the honorary president of ICCA. He is the only Indian on the ICSID panel and the only Indian to be appointed arbitrator in investment treaty arbitrations where India is not a party, including as chair of the tribunal. With these words, I would like to request Mr. Nariman to enlighten us with his thoughts.
Chief Justice of India, Minister of State for External Affairs, Secretary of UNCITRAL, my good friend, the distinguished Attorney General for India, judges, ambassadors, distinguished persons, ladies and gentlemen. I'm aware that I stand between you and dinner, so I have to be careful. Thank you, Madam Secretary, for the update on the UNCITRAL countries and the ISDS reforms. The information you have given us will be most useful for participants and attendees in the 1.5 days that follow. As for the Chief Justice, I am privileged to have known him for many, many years. I've been an admirer of his ability to do several important things well at one and the same time. As Kipling used to put it, he fills the unforgiving minute with 60 seconds worth of distance run. And he is a great example for us all, young and old, practitioners of law, of arbitration, mediation, and conciliation. And I suggest you give him a big hand. As to what I have to say, I might take my cue from an American who was awarded the Nobel Prize for Physics back in 1961. In his acceptance speech in Oslo, he said, and I quote, "Understanding a subject means reducing it to a freshman's level of simplicity." The subjects that are to be discussed tomorrow and the day after are not simple at all. They are complex, ranging from regional perspectives on UNCITRAL to reforms in investor-state dispute settlement with a manifold range of subtopics. Permit me then to make a few frank comments from the point of view of a freshman. And you will pardon me that if I give you a slightly worm's eye point of view. In most professions, the possibility of occasional error is frankly admitted and even guarded against. More so in court systems, which provide for a succession of appeals. But the practice of international commercial arbitration, prevalent for many decades now, and the practice of international investment arbitration, a more recent phenomenon, continues on the questionable assumption that an international arbitration is hardly ever wrong. That is because of that supreme sense of complacency that pervades international commercial arbitration and its myriad manifestations, including investment treaty arbitration as well as conciliation. This supreme sense of complacency got exemplified in a remark made in pre-World War II days by a former Lord Chief Justice of England. At a Lord Mayor's banquet given in his honor in London way back in 1936, Lord Chief Justice Hewitt had said somewhat pompously, "His Majesty's judges are supremely satisfied with the almost universal admiration in which they are held." Substitute international arbitrators for His Majesty's judges, and you will get the current view of international arbitrators on arbitration and arbitrators. David Pannick, Lord Pannick, who had argued the Brexit case in England's Supreme Court before all its 11 judges, had written a book titled Judges. In the book, after quoting Lord Hewitt, he said, "It is difficult to believe that the universal admiration his lordship spoke about reflected the true feelings of many of the customers of Lord Hewitt's court. Likewise, I am of the view that the users of international commercial arbitration, as well as the users of international investment arbitration around the world, are not exactly euphoric about awards handed down by international arbitrators from time to time. The reason is, of course, is that though judges are fallible and do often admit it, arbitrators are not less fallible, but the trouble is they simply won't admit it. We practicing lawyers have our favorite stories of questionable court decisions, and we keep unfolding them, though frankly never in front of the judges for fear of offending them. Professor Goodhart, was a famous editor of the Law Quarterly Review in England for 50 long years. When he retired, a law lord, Lord Diplock, wrote a commemorative piece about him. He wrote that he always thought that Professor Goodhart was on his side, because whenever his own Lord Diplock's judgment was commented on by Goodhart in the Law Quarterly Review, the remarks were always prefaced with the words, "with greatest respect." And Diplock said to himself, "This is great. This must be because we both went to the same university." But he was wrong. Only later, much later, Diplock realized that Goodhart had let it be known how he had learned how to sugarcoat a bitter pill, that is, how to criticize a decision without appearing to be offensive. He learnt it from the great jurist Sir Frederick Pollock, of Pollock and Mullah fame. Pollock had said, and I quote, "If you are doubtful whether the judicial reasoning in a given case is wholly unassailable, you must preface your comment on the decision with the words, 'with respect.' If the decision is obviously wrong, you substitute it with great respect. But if it is one of those decisions that have to be seen to be believed, the formula is with greatest respect." So it is with arbitral awards, ladies and gentlemen, in international commercial arbitration and international investment arbitration. You have known and I have known of arbitral awards, some of which have to be seen to be believed. But of course, we never admit that such awards are ever mine. They are never mine. They are never yours. They are always someone else's. India's experience in international commercial arbitration started way back in the 1920s, more than 100 years ago. But it was haphazard because we in India had no enacted law on international commercial arbitration. It was UNCITRAL that helped to remedy this. The Afro-Asian Legal Consultative Committee was responsible for the initiation of a study by UNCITRAL that led to the formulation of the model law. The study of the Secretariat of the AALCC indicated that the rules of then existing arbitral institutions were heavily weighted against the interests of developing countries. AALCC, that is the Afro-Asian Legal Consultative Committee, was the catalyst for the formulation of the 1985 UNCITRAL model law, which is amongst the great showpieces of UNCITRAL. After the UN General Assembly adopted the UNCITRAL model law in October 1985, the resolution of the United Nations recommended nation states around the world to enact legislation according to its terms. India's Arbitration and Conciliation Act was passed in 1996, and it contained for the first time a definition of international commercial arbitration. At the time it was enacted, the Act broadly conformed to the UNCITRAL model law of 1985. But, and I say this with some regret, with a series of subsequent amendments made by the Amendment Act of 1916 and the Amendment Act of 2019, I said 1916, I'm wrong, by the Amendment Act of 2016 and the Amendment Act of 2019, as well as some court decisions, the 1996 Act went off the rails, and there came into existence far too many conflicting judgments on different provisions of the Act, all of which are yet to be reviewed by larger benches of the India's Supreme Court. Ultimately, in June of this year, June 2023, the Government of India constituted an expert committee to reconsider the provisions of the Arbitration and Conciliation Act 1996 and to advise whether there should be a modification of the existing law. The committee has since made its report. At the moment, the report is confidential because the Government of India is considering the report and will give its considered view on it sometime near the end of the year. Meanwhile, I am sorry to tell you that arbitration law in India is in a somewhat chronic state of animated suspension, which is really, for me, a pity. The problem is that when after years, not months, but years of confabulation and discussion that had taken place in the formulation of the model law, the majority of nation states around the world chose not to adopt it in its entirety, but enacted national laws with different variations and different alterations. Thus far, 87 nation states have fashioned their laws on the model law, adapting but not adopting the UNCITRAL model law. The exceptions are only 3 states: Canada, the federal law of Canada, Australia, and Hong Kong. One major problem remains, namely the current system of challenge under applicable rules or ad hoc practices, even under our 1996 Act, for challenging the independence and impartiality of the arbitrator or of the chairman of the arbitral tribunal. I'm afraid it is heavily loaded in favor of the arbitrator who is challenged. My own experience has been that it is just not possible to get rid of an appointed arbitrator or chairman of an arbitral tribunal when there is some reliable information in the possession of the challenging party, which, for want of proof, cannot be established in a court of law and therefore cannot also be revealed. Under the present dispensation, there has to be disclosed some good reason, not suspicion, some good reason that the person already appointed is not likely to be impartial, which is an uphill, almost impossible task. However, and this is good news, ICSID has pointed the way. Challenges to appointed arbitrators under the ICSID regime have been far more successful in recent years than they were in the past. In several recent cases, challenges to the independence of arbitrators under the ICSID regime have been successful only by applying not the established standard of high probability of bias, but of a much lower standard of reasonable doubt. This has helped restore some degree of accountability in the investor-state arbitration system or the ICSID regime. We definitely need more calls for greater acceptability of arbitrators to international commercial arbitration and in investor-state arbitration. Besides all this, since an award rendered by an international investment arbitral tribunal is final and binding, and because recourse against it on merits is presently not available at all in national courts of law, either under the New York Convention, under UNCITRAL, or even under ICSID, I believe there is need for provision being made in the bilateral investment treaty itself for an internal appeal, or at least an agreed internal mechanism for the tribunal itself to review its own award at the instance of a party aggrieved, not only for correction of patent errors, but even for correction of errors that are not so obvious or patent. After all, arbitrators, like judges, are human, and they can err, and they often do. In international commercial arbitration, the greatest problem today is that a quick, not so expensive, and yet expert resolution of the dispute is difficult. almost impossible, but it is something earnestly to be wished for, about which there is a story. Not my story, it is a story that my good old friend, Professor Emeritus William Park of Boston University, likes to tell. And this is how it goes. This is the story. There is a sign in the window of a shoe repair shop in downtown Boston. It is run by a Greek immigrant who is fed up with customer complaints. So he puts up a sign in a triangle connecting three expressions. At the top, fast service. One side of the triangle, low price. Third side of the triangle, high quality. Fast service, low price, high quality. And underneath is the all-important expression, pick any two. Because all three together, fast service, low price, high quality, at the present moment are simply unattainable in international commercial arbitration and in international investment arbitration. I sincerely hope that your discussion tomorrow and on the half day to follow will result in finding some solution to this conundrum. And I wish you all a very pleasant and rewarding conference. Thank you.
Thank you, sir, for bringing in some humor through the wonderful formulas, which ensured that our audience forgot about the dinner. So with this, we are coming towards the end of this inaugural session. A big thank you to one and all for your participation at this session today. Special thanks to the speakers for enlightening us on the final details of arbitration. Thank you to Honorable Chief Justice of India for highlighting the importance of this conference and how the ideas discussed here are morphed into law, being access to arbitration for small businesses being a case in point. He highlighted the South Asian cooperation in the legal field through the MOU between India and Singapore on judicial research. He also highlighted how Indian federal structure serves as a platform for healthy competition among states for best business outcomes, including in dispute resolution. Harnessing the technology through adoption of AI-assisted learning, the machine learning, and the National Judicial Data Grid adopted today is a phenomenal step by Supreme Court of India that will enhance the justice delivery system in our country. We learned about the work of UNCITRAL, including the International Legal Framework for Shipping, the work by UNCITRAL on access to credit for MSMEs, ISDS reform, the dispute resolution on digital economy project, and various other works being carried on. Attorney General of India highlighted India's contribution to Commonwealth of Justice and Peace, our journey into the arena of investment treaties, and the case for New Delhi Declaration on Global Investment Law. He also highlighted how India has finally made the arrangements for the seat of Permanent Court of Arbitration in Delhi and will soon see the light of the day. So a big thank you for the patient hearing and listening to the esteemed guests and the audience. So before we end this session, Attorney General of India would be presenting mementos to the esteemed speakers. So, Thank you. So this was just the beginning of our journey into the world of arbitration that will continue for tomorrow and the day after. And we look forward to your participation in the rest of the conference. Now, I would request all of you to remain seated while our speakers and the esteemed guests in the first 4 rows proceed to exit the hall. Thank you. Our esteemed guests in the first 4 rows are requested to proceed for the dinner at the ground floor.